Thank you, Madam Speaker, members. I've got 3 points, 3 arguments to share with you today in the hopes that some of you who are sitting on the fence think deeply about the jump, the leap you're about to make on behalf of the state of California. The first argument really has to do with the process, as my colleague pointed out. You lose something in making legislation when you rush it. You lose the ability to deliberate, to bring in experts, to bring in people that know what they're talking about. Some of you, and I don't mean any offense, but some of you probably don't know the difference between jail bail and a bale of hay. And that's not a slight. That's a reality. We're all trying to make policy in a complex, diverse, enormous state with 40 million people in it. And the best way to do that is to deliberate and bring in experts and think about things and run them through the process that we all trust and rely on to come out the other side with thoughtful legislation, agree or disagree with it. And this is no small change. Make no mistake, if you don't work in this industry, this is a giant, giant, life-changing, life-altering change for every single Californian. You can't just take what's been done in New Jersey and New Mexico, copy and paste it to California. We're bigger, we're more diverse, we have unique challenges, unique laws, and unique problems and difficulties. The second point I'd like to make is to ask you to consider this. What does it say about a bill? A bill that has been rushed in the process to the floor. When the opposition groups include the ACLU, the NAACP, the Bail Bonds Coalition, although that's probably obvious, lots of sheriffs from around the state, lots of law enforcement groups from around the state, police chiefs and Crime Victims United. What does it say? Does that tell you, is that the indication of a fully baked bill? Is that the indication of a policy that we can all get behind since we're changing the entire structure of the criminal justice system today? Lastly, to the merits of the bill. Under the current system, I'm not here to tell you bail is perfect. There's changes we can make. There's things we can improve. We're doing pilot programs all the time. What's wrong with the pilot program? Let's try it out. Find the worst place. Find the county where it's the most broken. Wherever that is, try a pilot program out for a while, study it, and see if it works. See if it actually makes us more safe. See if people show up and not fail to appear in court under the new risk assessment system. This is what it does. Trust me on this. We're going to take power away from judges and away from attorneys that have the chance to argue whether there should be bail and what amount it should be set at. And a judge that has the power under the current system to decide that. Thousands and thousands of people a day are in court, every single day in California. And judges are making thousands and thousands of these determinations based on the individual facts in front of them. The person's history, whether they failed to appear, the severity of the crime, the risk they pose to the public. That's already being done by a judge under the current system. This would wipe most of that away and leave a bureaucracy that's underfunded to do even more work. And I'm sorry, folks, you can't reduce everything in life to an algorithm, to a computer program. I have seen, as a prosecutor and as a criminal defense attorney, I have seen hundreds of cases where risk assessment tools failed. They failed victims and people and defendants on all different sides. You can't just take something out of a computer and press a button and get a prediction that's going to allow you to make an intelligent choice about whether something's safe or not, whether somebody's going to appear in court or a flight risk, or whether they're a danger to the public. Lastly, I'd suggest part of the reason you've seen some of these groups, like the ACLU, which I've fought, in the last 2 years I've been here, I've fought them in all sorts of bills, man, but once in a while they are on point. And they're on point with this one. This is going to lead to some people who have no business being incarcerated. You know, there's a constitutional right to bail. You have a right to post bail under the Constitution. I'm not sure this bill is even constitutional. It's a pre-trial detention. It is a detention before anybody, a jury or a judge, has told you you're guilty. It's a deprivation of liberty. And you have a right to post bail on almost every offense there is under the law. So you can work with your attorney and remain unincarcerated while you prepare for trial or get your case resolved. This is going to diminish that right for certain people. On the other side, there is going to be dangerous people that are going to be out and are going to fail to appear in court at their court date. The failure to appear rate for, regardless of offense, for people accused of felonies is incredibly high. Go study that data. Please study that data. There are going to be people that fail to appear, that are blessed to remain at large in public by a bureaucracy, that go out and do terrible things to people.
Assemblymember, if you can bring your arguments to a close, your time is up.
I respectfully ask for a no vote.
Thank you.